just want to echo what Peter said, and thank you all for still being here, and thank you, Ronan, thank you to everyone else who put this together, and of course to Create and the Wellcome Trust. What I want to talk to you about today is really just one slice of the digitization question, but also to frame that in context and to suggest that for those of you who didn't realize that you should be really concerned about data mining, you should all be really concerned about data mining. Here's an abbreviated timeline of the Google Books project litigation. It's intensely abbreviated. But essentially, as I'm sure almost everyone knows, Google announced its plan to start digitizing libraries to make them searchable in 2004. Authors Guild class action lawsuit followed fairly shortly after that. We got distracted for a few years on the rather ambitious settlement proposal. Settlement was rejected, and then in September 2011, the Authors Guild filed a separate suit against the university libraries. So that is the Hathitrust lawsuit. Now, possibly surprising to the Authors Guild, that case proceeded really quickly and jumped ahead of the versus Google decision, so that Judge Baer gave us a positive ruling on fair use for libraries before the other court has had a chance to make a ruling on fair use about the Google Books project at large. In fact, we just had oral argument on that on Monday, and the transcript of which is incredibly encouraging. So, my broader point, there are different kinds of digitization program. They each raise different legal issues and bring in different stakeholders, and this is an important thing to keep in mind. Broadly speaking, I think you can categorize them in terms of preservation, data production and analysis, and then as display, actually giving access to these works through some kind of digital vehicle. And in terms of display, I think you have to slice that up even further to talk about the special issue of providing access to the visually disabled, and then scholarly access, and then general access. Depending on what kind of digitization project you're thinking of, the implications will quite naturally be different. Now, I've asterisked two of these because these are the issues that we got a positive fair use ruling on in the Hathitrust case. I actually think Judge Baer was quite skeptical of the preservation case, although without ruling against it. Library digitization for the production of data, I think, is an important strategic issue. It unites commercial and non-commercial interests. It has a strong, I think, almost undeniable normative appeal. It raises some fairly clear orphan works problems. And most importantly, once you accept the argument, then you accept the argument for digitizing the whole collection, which again re-emphasizes the orphan works problem. What this means from a litigation context is that, in Google Books, for example, if you agree that it's okay to digitize a library to build a search engine, but let's say you think a 3-line snippet is too long, you think that it should only be a 2-line snippet, then there's no class. You have to go in and you have to look at every work and to see whether it was insnippiated or not. And that is a much more difficult lawsuit for the plaintiffs to bring. So even if you don't actually care that much about data production without snippets, it's still really important as an issue. So I want to discuss the legal argument, which I think works in the US and should also work in every other country. My terminology may require some local adaptation. But essentially, we're talking about digitizing non-digital objects in order to extract data from them, and in many cases to compile new data about them. This metadata as just a matter of textbook copyright law is not copyrighted. Copyright protects expression. It doesn't protect facts and ideas. It certainly doesn't protect facts about a work. Everyone knows this, but it's important to remind people of all the reasons why this must be true. In the US, we have a very clear idea-expression distinction in our law. We also have this thing called the merger doctrine that says when an idea can only be expressed one way, the freedom of ideas trumps the protection of expression. More importantly, metadata, data about a work, is not actually substantially similar to the work, nor does it originate with the author of the work. And I like to explain this in terms of whales and dinosaurs. This is a text analysis of Moby Dick. The word dinosaur appears 0 times in Moby Dick. The word whale appears over 1,000 times. Neither of those observations are substantially similar to the underlying text, you'll notice. Neither of those observations can honestly be said to originate with the author of Moby Dick, Herman Melville, although, but for his creation, I could not make those comments. And in case you don't like graphs, I also have the same data arrayed as a word cloud. Again, this is not substantially similar, nor does it originate with the author of the text. Having, I think, established proposition number 1, we go to the slightly more difficult proposition number 2, which is that a copying process that only produces metadata does not infringe. In other words, that the intermediate non-expressive use here is either just not copying in the relevant sense, which does require a sort of metaphysical understanding of copying, sort of when the tree falls in the forest, no one hears it. In the US, it's much easier. We just say, well, it's fair use. It is technically copying, it is technically a reproduction, but it's not infringing. Essentially, the argument is that we recognize already that parts of a work may not be copyrightable, the facts and ideas within them. We just need to port that distinction over to our understanding of acts of infringement. The fundamental justification for this approach is that copyright is ultimately about the communication of expression to someone, to the public. And so when things are copied purely for internal computational reasons and not to convey their expression to the public, then that is something that should not be recognized as copyright infringement. I'm going to skip the application to fair use because none of you should really care too much about our statutory factors. And I'm going to move along to legal argument number 3, which is that non-expressive use does not harm copyright owners and has great social value. Here is the explanation we used in the digital humanities brief, which Judge Baer mentioned in the judgment, Judge Chin mentioned it in oral argument in the Google Books case on Monday. Made me incredibly happy because I spent a long time getting this graph to work. It's a contrast using Google Ngram data of the United States is versus the United States are. If you say the United States is, then you think of the US as a single entity. Are, by contrast, you still think of it as a collection of states. This shows the occurrence of those two expressions graphed over time, and the crossover is pretty much dead on the Gettysburg Address, this conception of the United States as a single entity. This does not infringe the copyright in any of those underlying books. You can't just look on the index for books about the United States and compile this graph. You need to scan everything. It does not actually reproduce any text from the underlying works. We found this to be a compelling yet simple example. Here's a slightly more complicated but far more brilliant example from Matthew Jocker's book on macroanalysis. Matthew's one of the other authors of the digital humanities brief. He's an English professor. he managed to show that there's an incredible spike in Irish interest in the topic of slavery during the American Civil War, but that there's no corresponding spike in British interest and a slight increase in American interest. That is a fascinating result that demands further exploration. Now, he did this based on scans of out-of-copyright works. He can't do this in the current century. He is, as he said, a slave to the public domain, which is a regrettable situation. Or rather, perhaps was a slave to the public domain. Matthew and I and Jason Schultz from Berkeley, now at NYU, we wrote this brief on behalf of the digital humanities to focus attention on this issue as a standalone issue, to make sure that it was not lost. We wanted the court to be very clear that this is not just a Google issue, it's not just a research issue, it's not just an internet issue, it's an issue with profound implications. And we gave them powerful examples that were tied directly to understanding literature so that they would get that this was something that was not antagonistic to copyright. And of course, if you understand the way search engines work, you realize that this conclusion is vital for search engines. I was puzzled to see that the proposed legislation in the UK will still make commercial plagiarism detection software illegal. Commercial internet search engines presumably still illegal because they don't fall under your new proposed data mining exception. Software that searches for copyright infringement actually will necessarily still be illegal, which is kind of unfortunate and ironic. In the conclusion to the Hathi Trust case, Judge Baer acknowledged that these facts were novel, but said, in a quote that just made all of us so happy, that essentially he could not imagine a version of fair use that would make this valuable contribution to knowledge and to giving access to disabled people illegal. And I've also put up a couple other quotes from the brief, but I will elide those for the sake of time. The nice thing about writing this brief was I got to work closely with people who aren't lawyers, people from linguistics, computer science, English literature, history. We also got to write essentially the same brief 3 times, so that made me look very productive. We also wrote a 2-page comment that was published in Nature, which was certainly an added bonus. And we got some positive feedback from the courts, which is always nice. What's really nice is to be able to advocate a position that I think is so important and to feel like we had at least a little bit of a contribution to make. I want to conclude by acknowledging that your precise legal issues are different. You, unfortunately, although fair use started in England, you abandoned it about 100 years ago. The underlying policy questions, I think, are universal. Everyone recognizes that copyright is not about facts and ideas, that it really is about expression. And I think that we all recognize the promise of big data and the problems of orphan works. I think that the challenge for this community is on conveying the importance of this to the relevant bodies, which I think here are legislators and the gentlemen from the IPO as much as they are the courts. In terms of action items, I really want to stress, do not be in such a hurry to leave your commercial brethren out in the cold. If you want these exceptions purely for non-commercial activity, then they will always be treated as a subsidy. Subsidies don't last forever. Also, if you want there to be libraries, libraries to scan, to perform digital humanities research, someone has to scan them. and it's expensive, as you know, to do en masse. So again, don't be too quick to embrace solutions that only work for non-commercial entities. And the other, I think, lesson here is the advantage of flexible limitations and exceptions. In the US, the HathiTrust case is just the culmination of a series of cases dealing with internet search engines, plagiarism detection software, etc. It was actually not too difficult for the court. I don't think that that's the same when you have a more restrictive approach. Finally, I just wanted to pop up a slide to say what I think the open and closed issues are now in archival and digitization work in the US. Preservation, still an open issue, but the signs are not encouraging. Orphan works display, completely open, not ripe for adjudication in the HathiTrust case. Disability access, I see that as something that has been won. I don't think that's getting overturned on appeal. Data mining, I'm pretty confident about as well. Library copies as a quid pro quo. By this I mean Google's agreement with the libraries was, we will scan your collections, and in consideration, we will give you access to digital files. The reason that works in the US is because we have a voluntary copy doctrine. Google says, we're not actually copying, we're just making it possible for the libraries to copy, and the libraries are fair users, which completely works under US law. They could still be liable as a secondary party, but they're not because the libraries aren't infringing. Making and retaining expressive copies. The Authors Guild have just started to argue that, well, even if you need to scan something to make a disabled access version, you should immediately destroy the original scan once you're done. So it's okay for blind people to be able to listen to books. It just has to be as expensive as possible and to redo the process every single time. That honestly appears to be the message. Still open, I'm expecting that one to get shut down. Snippet display, the most boring copyright discussion in the world, because ultimately you have to accept that there's some length of acceptable snippet. So is this just an argument about whether it's 2 lines or 3 lines? It seems completely asinine. But still open, and we're expecting a ruling on that soon from the district court. There are a whole bunch of really fascinating procedural and class action questions that are of no interest to you whatsoever, so I will leave them. And then I just have on the slide some further reading. This picture is from Matthew Jocker's book. It's really interesting if you go and read the article in Nature. Thank you very much.